Apple Ireland case, July 2020. Apple Ireland. Apple Inc. US. This is US. Fully owned subsidiary. Apple Operations International. This is Ireland. Fully owned subsidiary. Apple Operations Europe, AOE. Fully owned subsidiary. Apple Sales International, ASI. These two in Ireland. This is in US. Fine. AOE and ASI, they are incorporated in Ireland. But they are not tax residents of Ireland, mind you. Fine. And AOE and ASI, they also have Irish branches, PEs. But they were using the term branches, so I told you branch is also PE. But fine, these are Irish branches. Why Irish? Because they are in Ireland. Fine. Irish branches of AOE and Irish branches of ASI. Fine. Okay. And Apple Group has licensed the relevant IP to license the IP to AOE, ASI, license IP, license, and this is a royalty free license, royalty free. So this is royalty free license. Fine. This was basically a state aid case, that is European Commission versus Apple and Ireland. European Commission state aid case under Article 107 of TFEU, Treaty on the Functioning of the European Union. One of the two treaties which form the foundation, the fundamental basis of the European Union. Other one is TEU, Treaty on the European Union. Article 107 of the Treaty on the Functioning of the European Union, that deals with state aid law. European Commission, which is the watchdog of the European Union. European Commission was alleging that Irish tax authorities and therefore Ireland have provided undue tax advantage to Apple. Fine. And by providing an undue tax advantage to Apple, state aid rules under 107 have been broken. Why? Because if any of the countries within the European Union provides undue advantage out of the state resources to any of the companies, then this would be to a disadvantage of free competition existing in the European Union. Don't go into that area, but this was the case. Fine. Okay. So what was the Commission's case? How did Commission say? How did Commission allege that Irish tax authorities have provided an undue tax advantage to Apple? They were saying, Commission was saying that Commission wanted that the IP licenses. Now understand, AOE and ASI are incorporated entities. They are companies, and these are branches. These are PEs. And these PEs, they don't have a separate legal existence. We've seen this. Fine. Okay. So whatever profits they would be determined, whatever profits would be attributable to these branches, they would be subject to tax in Ireland. Fine. But AOE and ASI, because they were not tax residents in Ireland, so the profits attributable to AOE, this legal entity, and this ASI, they would not have been taxable. Why? Because they were not tax residents. So Commission was alleging that these IP licenses which have been licensed by Apple, parent entity, Cupertino, US, these IP licenses which have been licensed, which have been licensed to AOE and ASI, they were saying, Commission was saying that these IP licenses should have been attributed to the branches. They wanted to have this, that these IP licenses should have been attributed to this, to this branches. So when the IP licenses would have been attributed to the Irish branches, that is why all the returns, all the profits that would have arisen on account of exploitation of those IP licenses would also have been attributed to the Irish branches. And because the profits would have been attributed to the Irish branches, that is why Ireland would have got a right to tax those profits. And how did Commission build its case? They applied AOA approach, this approach that we've done. They applied that AOA approach, authorized OECD approach, and they were trying to make their case that in the dealings between AOE and the branch, ASI and the branch, significant people functions, function asset risk analysis, accordingly everything said and done, this branch and this branch should have been attributed the profit, arising out of the exploitation of those IP licenses. So this case in effect was the direct application of the two-step authorized OECD approach, that is attribution of profits to permanent establishments that we just now see. Accordingly, arm's length principle, as we've seen that in these dealings, arm's length principle will be applicable in step number 2. In step number 1, we'll hypothesize them as separate entities, and in step number 2, we will attribute the profits. So, is this case, I mean the direct application of the two-step approach that we have just now studied, does it make sense that this is how you can see the application of two-step approach in practice? Obviously, in this case, Commission lost because Commission was not able to prove their allegation. They were not able to show that on the basis of FAR analysis. The IP licenses should have been attributed to the branch. The DEMPE functions were not performed by the branch. They were performed by the AOE and ASI, and that is why they lost. Clear? Making sense? This is Apple case. Yes? Quickly.
Branch.
Pardon me?
What? DEMPE functions were not performed by the branch.
Yes. They were saying Commission was saying that DEMPE functions are being performed by the branch, but when actual fact finding was done, they were not able to show that DEMPE functions were performed by the branch. So that is why they lost. Commission lost.